Good morning, everybody. Can you hear me?
Good morning, Judge. We can.
Nice to see you, Mr. De Beer. Mr. De Beer, can you unmute
Yes, I'm busy doing that, Justice Steyn.
Thank you.
Thank you.
Mr. Bromley, if you wish, you can
Good morning, Judge. We can.
mute your obviously your microphone as well as the camera once we're going, for the sake of not losing data or connections.
I'm busy doing that.
Anything else that you want to
Justice
suggest? You
Steyn.
know more about these things than I do, Ms. Pillay.
Thank you.
I see we do have recording in place.
We've got recording, Mr. Bromley.
Thank you.
Are you all ready? Is it in order if we start? Mute
Yes, thank you.
obviously your microphone as well as the camera once we're going, for the sake of not losing data.
Tonetha Jay and one other versus Mediclinic Pty Limited.
Anything else that you want to suggest?
Thank you.
You know more about these
Yes,
things
Mr.
than
De
I
Beer.
do, Ms. Pillay.
Thank you.
I see
Yes,
we
Mr.
do
De
have
Beer.
recording in place.
We've got recording, Mr. Bromley.
You may
Are
start,
you
Mr.
all
De
ready?
Beer.
Is it in order if we start? Mute your obviously your microphone as well as
Thank
the
you,
camera
Justice
once we're
Steyn.
going,
I will start.
Tonetha
Can
Jay and one other
everyone...
versus Mediclinic Pty Limited.
Anything else that you want to suggest?
Thank you.
You know more about these
Yes,
things
Mr.
than
De
I
Beer.
do, Ms. Pillay.
I can't hear you.
I see
Yes,
we
Mr.
do
De
have
Beer.
recording in place.
We've got recording, Mr. Bromley.
Yes,
You
sorry.
may start, Mr. De
Beer.
Beer. Is it
I've
in
got
order
a...
if we start? Mute your
I've got
obviously
an
your
echo.
microphone as well as
Thank
the
you,
camera once
Justice
we're going,
Steyn.
for the
I will
sake of
start.
maybe that's because there's another computer close to you, another laptop or computer or some sort of interference.
I can't hear you.
If you just mute the other device, Mr. De Beer, and zero the volume on it, it takes away the echo.
Okay.
Yes, Mr. De Beer, we're waiting.
Okay. Okay, that sounds much better. Thank you, Justice Steyn. I've sent the required heads of argument before the time, so I believe that Justice Steyn, you've managed to read it beforehand. In terms of paragraph 2.4 of the heads of argument for this application for leave to appeal, I've identified 3 points that I need to raise. The first one is the Equality Act appeal process. It appears as if the respondent do not have a problem with the fact that we have requested leave to appeal from this court, from the court. I've identified in paragraph 3 of my heads of argument that the Supreme Court of Appeal in the matter of George did indicate that leave to appeal must be sought first. Then in terms of section 16(1)(c) of the Superior Courts Act, it is clear that in a special court where of similar status as the High Court, like the Equality Court sitting at the High Court, leave to appeal must be sought from the court or from the Supreme Court of Appeal. And then further, section 17 of the of the Equality Act I beg your pardon, it's section 19(1) of the Equality Act makes provision that the rules relating to appeal above others of the High Court is will be mutatis mutandis applicable in this case as well. So in terms of Rule 49(1)(b) of the Uniform Rules of Court, 15 days are provided to lodge an application for leave to appeal, and we humbly submit that we did indeed file our application for leave to appeal within 15 days. So in terms of the legitimacy of this application for leave to appeal, we do not foresee any problem with it, and with permission of Justice Steyn, can we then continue?
That is why you're here, Mr. De Beer. Okay. I'm waiting for you to continue. If it was a problem, you would not have been here. So you can continue.
I take note. Thank you, Justice. Then the main issue in terms of the judgment of the 3rd of October was that I read paragraph 59 of the judgment itself, that on the point in limine whether this court has the jurisdiction to hear the application, it is ordered that this court does not have the requisite jurisdiction. This application is dismissed with cause. So the issue at hand, why the court dismissed the application, was because of jurisdictional concerns and issues. I'm going to go through the judgment itself to highlight certain areas which we believe the court respectfully erred. And I'm going to start off with...
Mr. De Beer, you've now referred me to the relevant law relating to why you're entitled to bring an application for leave to appeal. You have set out certain grounds for leave to appeal, which basically governs how this matter can be argued and what can be argued and what not. Furthermore, you've got heads of argument that you have to basically rely on to a large extent. I don't know on what basis you want to go through the whole judgment now. The judgment has been given, the judgment has been reasoned. I want to hear about the aspects that you complain about. In your grounds, there were certain grounds. You said there should have been an inquiry. You said I should have considered more information, etc., etc. So those are the aspects that are relevant and need to be traversed.
Thank you, Justice Steyn. That is exactly what I'm going to do. I'm not going to go in detail through the entire judgment. It's only those parts relevant to the reasons why we are requesting leave to appeal. So, firstly, let me start off that in terms of paragraph 11 of the judgment...
Where is that in your heads of argument?
I beg your pardon, Justice?
Where do I find what you want to argue in your heads of argument?
The main points that are raised in the heads of the application for leave to appeal...
Mr. De Beer, we're going to take a whole day if you don't respond to what I'm asking you. I'm asking you, where in your heads of argument are you dealing with what you want to argue now? So that I can look at it in paper.
It's all relating to the jurisdiction, the jurisdictional issues. Firstly, let me start off, because this is the basis of the fact that the complainants believe that the court did have jurisdiction, and that the court was not in a position to have dismissed the application based on jurisdictional grounds. That all bears down to the inquiry itself, the mandatory inquiry that should have been held. So that is in paragraph 5 of the heads of argument. So let me start off by dealing with the inquiry itself.
Let me start off by telling you that the matter was before me on 2 preliminary points by agreement. It was not before me to have an inquiry. In fact, the documentation for an inquiry was not before me. You provided me with the documentation personally when you would not allow Mr. Bromley to assist. So I got the documentation from you. And if you roll your eyes, I see it. Secondly, the aspect was jurisdiction and whether or not you were a suitable person to represent the complainants. Those were the two preliminary issues. That was all that was argued. I can refer you to your original heads of argument when both you and the respondent said the issues to be argued were these two preliminary issues only. So don't say to me that, and I see your heads of argument rely at the moment heavily on the fact that there should have been an inquiry. It was not before me to have an inquiry.
Justice Steyn, exactly. That is why the court did not have the jurisdiction to have made a dismissal order. The court cannot make an order to dismiss the application if a formal mandatory inquiry has not been held. That is
why did
a
you
stipulation.
why did you agree? Why did you agree that there would be two preliminary issues only? And why did you only argue two preliminary issues if you say the court should not have heard the matter without an inquiry? If that was your stance, it should have been your stance from the start, surely?
Justice Steyn, that was exactly what was argued during the hearing that was held in Cape Town.
I've got your heads of argument with me. There is no such argument in your heads of argument.
Justice
Your original heads of argument.
Justice Steyn,
your original heads of argument were quite clear.
Yeah. Justice Steyn, what was argued before the court?
Argument, no, I don't want you to be misguided, Mr. De Beer, because then your argument will not assist me. Your original heads of argument said the purpose is to address only 2 points in limine, which the respondent raised, namely confirmation of De Beer's representation and jurisdiction of the Equality Court. That's what you said, and that is how you dealt with it. You dealt with complainants, you dealt with standi, and then you dealt with the rest of the matters, with the jurisdiction of the court. That's what you dealt with. Two issues. Nowhere was it insisted that there should be an inquiry. In fact, how do you proceed? How do you think an inquiry would proceed? Will you tell me? How would it proceed? How, if I had to have an inquiry on that day, if you had argued that I should have one, how would it have proceeded then?
Justice Steyn,
I would have had to call people to testify. Is that not right?
Justice Steyn, it was a direct...
One of those people would... Your client would have been
Justice
one of them.
Steyn, you're not giving me opportunity to answer you.
Because I want to ask you questions, which is why I don't like this virtual hearings, because you interrupt me all the time. You have to listen to what I have to say, otherwise I can't help you. So what I'm telling you is, how would an inquiry have proceeded? What would have happened?
Justice Steyn, an inquiry is prescribed by the Act itself in terms of Section 21 of the Act, and then it is further highlighted...
Mr. De Beer, I'm sorry, just tell me the practicalities. What would I have done if an inquiry proceeded in terms of the Act?
Justice Steyn, with all due respect, you are not giving me any opportunity to answer. You are the only one who's doing the talking at this stage, respectfully said. I want to please proceed with this leave application, and would you kindly allow me to proceed?
Would you kindly respond to my questions, Mr. De Beer?
Justice Steyn, I would love to do that. The inquiry itself, there was a direction by Justice Ndita that we deal with two preliminary points. As I have addressed the court during the hearing itself in Cape Town, I have specifically said that there should have been a follow-up directions hearing. It was not finalized. So we had to deal with a directions hearing, and unfortunately Justice Ndita recused herself before the second directions hearing could proceed. So unfortunately, you, Justice Steyn, was seized with this matter based on a direction that was called for by Justice Ndita, based on two preliminary points, and we have, throughout argument in court, I have repeatedly stipulated that where this inquiry or where that hearing was fitting into the context of the Equality Act is now nowhere to be found. And I have referred to the fact that we need to have an inquiry in order for the court to be seized with the jurisdiction to make a finding whether discrimination took place, yes or no. So unfortunately, I was left in the position, or the complainants in this respect have been left in the position based on a direction that was not actually finalized at the end of the day by Justice Ndita. So I'm coming back to the fact that the Equality Court, when going to the Equality Court is supposed to deal with the case in a certain prescribed way. So the first option is the first hurdle to be to overcome is the first one in Regulation 6.4, which basically says that within a period of 3 days the clerk must forward the application after the submissions of the respondent has been received to the allocated judge, and the allocated judge must then, within a period of 7 days, decide. Only 2 options are given: whether the court will proceed with the matter or whether the matter will be referred to an alternative forum to address. However, Justice Ndita continued with a directions hearing, meaning that the procedures set out for an inquiry were supposed to be identified, which would have eventually happened on the second directions hearing. But after the first direction hearing, we were only left with 2 points, namely the one was, as we said, the jurisdictional issue raised by the respondent, and secondly, whether I was a suitable person to represent the complainants. Unfortunately, after that direction, there were no other direction hearing held. So we said, let's continue with the direction of Justice Ndita based on those 2 issues, but at the hearing itself, I did indicate that the court cannot dismiss the application before a formal inquiry was held. And in that respect, I can refer Justice Steyn to several authority on the aspect that I've also identified it in the leave to the heads of argument contained in the for the application for leave, where the Supreme Court of Appeal have specifically said that there must be an inquiry. Even the prima facie burden that the complainants had to overcome in order to then seemingly trigger the jurisdiction of the Equality Court, that also had to have been conducted at an inquiry. So, unfortunately, the court has taken what is before, as the court rightfully several times stipulated that I am a layperson, but the fact is that the Equality Court processes are made for laypersons. So it's there to make it easy for the grassroots level people to access the court, and in this respect access the High Court, which usually is a very difficult court for any layperson to access due to its practices and the rules governing it, and also that legal practitioners are they specifically allocated to a High Court matter. So we have chosen, the complainants have chosen to do it, use an informal forum sort of a less informal forum than the High Court to address the claimed discrimination matters. So in order to have prima facie proved, we were supposed to summon witnesses. We were supposed to question the witnesses of the respondent, and then only. And that is also the problem, that basically all the authority relied on by the respondent were authority after an inquiry was held. Even the Manon case extensively deals with the right of a complainant to have a formal inquiry. But only parts of that was used to say that this court does not have the jurisdiction. But in fact, in paragraph, I will highlight that specifically. In paragraph 81 of the Manon matter, the Supreme Court of Appeal specifically said, but you know, this is a matter where the court needs to have an inquiry. It's if Mr. Manon requested an inquiry to be held, or witnesses to be called, then he had a right to do that, because it's made for that purpose. And unfortunately, the complainants never had the opportunity to have ventilated the quantum of proof to the court in order to have a sufficient inquiry. Then the other matter, the Consumer Protection Act. The Consumer Protection Act deals with discriminatory matters between a supplier, which is Mediclinic, and Dr. Jay and her practice. It's section 8 to 10 extensively in the Consumer Protection Act deals with that, and section 10 specifically gives the jurisdiction to the Equality Court to deal with that. And then the other matter, which has never been used, and although it's in the papers, in paragraph 22 of the judgment, the court said that, made reference that, let me just put it in record, as addressed in Mediclinic's answering affidavit, in order for the complainants to engage the jurisdiction of this court, a case of unfair discrimination or harassment must be demonstrated. Now, harassment has specifically been addressed under losses suffered in the founding affidavit of the complainants. It was specifically engaged, and when one reads the ultimate definition of what harassment is in terms of the Equality Act, it means that in section 1 of the Equality Act, harassment means unwanted conduct which is persistent or serious and demeans, humiliates or creates a hostile or intimidating environment, or is calculated to induce a submission by actual or threatening adverse consequences, and which is related to sex, gender, or sexual orientation, or B, a person's membership or presumed membership of a group identified by one or more of the prohibited grounds or characteristic associated with such group. So we have identified already in our heads of argument in the for the first hearing, for the initial court sitting, that the complainants are members of an identifiable group of those who do not subscribe to the normal COVID-19 narrative. And we are saying that throughout the papers, that because of the fact that the complainants did not agree with the approach of the Mediclinic management as such, and who have specifically told her that if you don't align yourself with our COVID-19 measures or our ideas, then you can find yourself another place to practice from. So if that is not an intimidating or hostile environment which have triggered at least then harassment as a matter which directly falls within the jurisdiction of the Equality Court, with all due respect, then we cannot. Then I honestly don't know what the court further requires to prove. We cannot prove
Mr. De Beer,
something that is not in front of the court yet.
Mr. De Beer, I see that you are reading. So the problem for me is, if I interrupt and I ask you anything, it is not that easy for you to respond. So just listen to me for 1 second so that I can understand. Are you actually disputing my finding that the court does not have jurisdiction? Is that part of your argument?
That is indeed the argument, and that was also the basis why the matter was dismissed, because of a lack of jurisdiction.
Very well. You may continue.
And it's very important, as I've also addressed in the application for leave to appeal itself, that the Consumer Protection Act was totally ignored. It was in fact stipulated in the judgment, for example, that that in paragraph 14 of the judgment, it was stipulated that we made a statement in the founding affidavit that in the middle of that paragraph it reads, for reasons that do not appear to be legally justifiable, she holds that the contract should be interpreted in her favor. Now, that is in connection with the lease agreement and all the measures that have been implemented by Mediclinic in order to immediately terminate the lease agreement. In the Consumer Protection Act, in section 4, subparagraph 4, specifically says that where the drafter, which is it's basically the contra preferentum rule in layman's terms set out in section 4.4 of the Consumer Protection Act, whereby it said that where Mediclinic drafted the contract and where there's an ambiguity and there's a confusion, then it needs to be interpreted to the benefit of the complainants. Because of the fact that the Consumer Protection Act and all the discrimination levied in Section 8 of the Consumer Protection Act, right through to Section 10 of the Consumer Protection Act, which ultimately sparked the jurisdiction of the Equality Court, have all been ignored by the court. I would like to specifically just go to Section 8 specifically, and I'm only going to refer to three. There's quite a number, but it's clear that this specific matter is incorporated in the jurisdiction of the Equality Court via the Consumer Protection Act. Section 8.1 says that, subject to Section 9, a supplier of goods or services must not unfairly. Okay, a supplier is someone like Mediclinic. In terms of the definition of a supplier in the Consumer Protection Act, Mediclinic is definitely a supplier, and services include rental of immovable property or rental of facilities or provision of facilities which Mediclinic have provided to the complainants. Then in Section 8.1a, it says that exclude any person or category of persons from accessing any goods or services offered by the supplier. It's indeed the complainant's case that they were excluded because of their belief, their opinion, to participate in certain facilities and in the use and enjoyment of the property or that was leased. B, grant any person or category of person exclusive access to any goods or services offered by the supplier. Then in that respect, those who did not side with the opinion of the complainants were, according to what was stated in the founding affidavit, which had to have been further proved by way of witnesses and further evidence adduced at the inquiry, those people were then granted certain other rights that were not afforded to the complainants, and then assigned priority of supply of any goods or services offered by the supplier to any person or category of persons. There specifically, Dr. Jay stipulated in her affidavit that where she usually got references for burn victims, she suddenly, or that privilege was stopped. So that is clearly something that the court had to inquire.
Mr. De Beer, that was explained in detail. There was a response to that allegation, and it was explained in detail.
Justice Steyn, what was before the court was not sufficient to be called an inquiry or to do an inquiry. And in terms of Section 21 of the Equality Act itself, which compels a court to have an inquiry, specifically said that after an inquiry is held, the court is then afforded with certain authorities. And
Mr.
so,
De Beer, I find it difficult. Sorry, Mr. De Beer, I have a right to ask you questions. That is why you are there, and that is why a judge is here. You are obliged to listen to the questions and try to respond to the questions, not just continue reading from the documents before you. So please listen to my question. Is your main argument with the judgment the fact that you say that there should have been an inquiry, or is your argument that the court does have jurisdiction? Or are the two linked?
It's definitely linked, Justice Steyn, that the court does have the jurisdiction, so it could not have dismissed it based on the fact that there was no jurisdiction, because there was. And secondly, if a proper inquiry was held, we are certain, the complainants are certain, by adducing or summoning additional witnesses, etc., to this inquiry that had to have been held. They were definitely able to have a prima facie case to prove, and then it was up to Mediclinic then to have either prove that there was no discrimination, or secondly that the discrimination was not unfair. So because of the fact, and that is so important in the Manon case as well, that it's so crucial for an equality court to take control of the case before it and get as much as possible information from both parties in order to make a right and just order, which we are saying have not occurred, respectfully said. We are also in that respect referring to the Irvin Berea matter, which the respondents will argue is irrelevant to this case because it refers to the eviction of occupiers. But the fact is that is a constitutional inquiry that had to have been conducted in terms to make sense of Section 26.3, which is also situated or a part of the Bill of Rights. So discrimination, unfair discrimination, is also part of the Bill of Rights. And I honestly don't see that the Constitutional Court at the end of the day, with all due respect, will not say that a similar inquiry had to have happened in this particular case in order to say that there was no jurisdiction because of that there was no discrimination at the end of the day, and that the court did not have all relevant information before it. So that is the crux of the matter, and so in that respect the Irvin Berea case is applicable and should respectfully be followed. And in that matter it specifically also says that if an inquiry is not held to get all the relevant circumstances, the court does not have a jurisdiction to make any order. So
Mr.
the court
De Beer,
could not have dismissed
Mr.
it.
De Beer, you consented and agreed that there would be only preliminary points argued, namely the jurisdiction of the court and the other issue which was not part of the order, but the jurisdiction of the court. The reason why there are preliminary points in certain matters is to see if the matter can be disposed of without an inquiry. The reason for preliminary points is to try and attend to a matter such as this expeditiously and inexpensively as far as possible. That was what the matter was all about. The hearing of preliminary points was agreed to by you.
Justice Steyn, firstly, the Irvin Berea matter specifically addresses the fact that even if parties agree to a settlement, it's still the court's obligation to have a full inquiry, which the Equality Court did not have. Irrespective of the fact that, and I honestly disagree respectfully, that there was an agreement that the matter needs to proceed to only hearing those two preliminary points. The fact is that Justice Ndita directed it to happen. I wanted, and that was also unfortunately the quarrel that started between myself and Justice Ndita about this very point, that for the second direction meeting hearing to be called, we have to sit and identify what needs to be put before the court.
If you do not talk sense, I cannot listen to you. What is before me, I read from your heads of argument in the original matter. Your heads of argument said, these heads are drafted to serve the complainants. The purpose of the heads is to address 2 points in limine. And then it's confirmation of your suitability and jurisdiction. And then you deal with the rest of it. And those are the only 2 aspects that you argued in the court. Now, if you want to show me in your heads of argument originally, when you refer to the fact that it should not be heard on the basis of preliminary points, but it should be heard on the basis of an inquiry, please do so.
Justice Steyn, if the Equality Court is a creature of statute, I cannot give away my rights to an inquiry. That is an obvious mandatory.
Are you saying that you gave away your rights wrongfully? Is that what you're saying? Are you saying that you actually made a mistake by arguing only jurisdiction by agreement? There was a lot of correspondence in that regard. You will recall that Ms. Pillay referred to it and Mr. Bromley referred to it. Correspondence was provided to me to see how it was in fact agreed that the only issues for consideration was basically the issue relating to jurisdiction as a preliminary point. It was not before me on the basis of an inquiry by agreement with you. So if you are saying to me that was wrong, then I must deal with that. That's a completely different matter.
Justice Steyn, at the hearing in
I'm reading to you from your own heads of argument originally. Your own heads of argument dealt with 2 issues, suitability and jurisdiction.
Justice Steyn, I reiterate that those are bound to have been made after direction by Justice Ndita.
Why did you not say so then? Why did you not argue that? Why was that
at the hearing?
Why did you agree to the hearing of preliminary points?
At the hearing in Cape Town specifically, I have reiterated what I have said now, that there cannot be a meeting or a hearing that was called in the way that was before the Equality Court in Cape Town, because there's no place for it in the context of the Equality Act. I have reiterated that, and I was not heard, unfortunately. I have addressed it at the hearing extensively, that the matter cannot proceed without an inquiry, and in court I've also even made reference to the Irvin Berea matter in the Constitutional Court. That was never addressed in the judgment at all. But if we must, at the end of the day, get a transcription of that entire hearing or sitting of the Equality Court, then we should do it. But we are now at the application, leave to appeal application stage. And I am humbly asking you, Justice Steyn, to try and remember that I did argue that in that way. I'm sure of it that I have argued it in that way, but unfortunately the court ignored it in the judgment, respectfully said.
That is why I'm giving you the opportunity, Mr. De Beer. Your heads of argument in the matter before me, do you have it with you?
I do, yes.
Well, then show me where in your heads of argument did you say that, in fact, there should have been an inquiry. Because that was not why the matter was before me, Mr. De Beer.
In the application for Justice Steyn,
I'm not interested in Judge Nadeem.
Yeah, can I kindly refer to paragraph 5 of the original application or the original heads of argument. In paragraph 5, I specifically said that the complainants respectfully argue that they have not only confirmed the jurisdiction of the court, but specifically in paragraph 5.2. The complainants after submission that this matter should, without any further ado, be referred to further hearing, preferably trial. 5.3, the complainants reserve their right to add or amend to these heads whenever required. And it was required at the hearing itself, hence the reason why I've made...
Mr. De Beer, the point is that you said the court did have jurisdiction and the court should find that you had jurisdiction, and then the matter would proceed to an inquiry, a trial. Have you any idea how expensive that would be and how long that would take? If the court did not have jurisdiction, what a waste of time and money that would have been.
Justice Steyn, the unfortunate incident of the order that was ultimately made was the fact that the jurisdiction was linked directly to whether discrimination took place, yes or no. Because the respondent argued that the complainants did not trigger the discrimination. Hence, we did stipulate that all through the papers, that discrimination took place. But just because the respondents, that I've also said that the purpose of what needs to be put before the Equality Court initially, when the Form 693 is completed, is basically just enough to see whether the matter is discrimination related, yes or no. And then I've also identified the one instance where the Equality Court does not have jurisdiction about regarding discrimination relating to the Employment Equity Act. And I've also said that that is the only instance in the Equality Act itself whereby a jurisdictional hearing could be relevant. in order to address whether the Employment Equity Act has been triggered, yes or no. And in this matter, it's clearly not. So this is plainly, in terms of Regulation 6 of the Equality Act, there's a specific process that had to have been followed. That the jurisdiction is confirmed the moment when the matter is referred to a directions hearing. A directions hearing should have then regulated how the inquiry have to proceed. And for a mere fact that preliminary points were addressed on a very strange, respectfully said, hearing that we held in Cape Town, that does not stop the Equality Court not to have a proper inquiry. So if it does take many hours in the Equality Court and extensive legal teams and many witnesses to be called, then that is unfortunately what the Equality Act says must happen. But unfortunately, the court took an easy way out.
Mr. De Beer, I'm sorry to interrupt.
Yeah.
Mr. De Beer,
I hear
your picture is breaking up tremendously. Would you please look at your connection and make sure that the matter can proceed? Otherwise, I can't proceed. I can't proceed if I see just a blur in front of me.
My connection is proper on my side. I don't see any disturbance whatsoever.
Your voice breaks up and your picture breaks up. Well, I have a lot of disturbance. Ms. Pillay, do you have any disturbance?
A fair amount of disturbance from our side, Justice Steyn.
Thank you.
We're struggling to hear as well.
Justice Steyn, if
Thank you.
you'd
And I can
allow
see
me
you
to just leave this and just try and reconnect, can that be allowed?
Yes, I will then leave for the time being. 3 minutes, what do you suggest?
That should be more than sufficient. Thank you, Justice Steyn.
Okay, well then 1 minute. The court will leave if I'm able to do so.
Hoorie, is julle op die internet? Asseblief nie.
Yes, Mr. De Beer?
I'm still connecting on my side. Can everyone hear me now?
Yes. Yes,
Okay,
please proceed.
perfect. Justice Steyn, yes. So the fact is that the jurisdictional concern of ruling of the Equality Court, in fact, engaged whether discrimination was applicable, yes or no. And we are saying that the court could not have made that determination without an inquiry that was held. Justice Steyn, I've addressed the issue regarding that. Let me just quickly go through the papers just to see whether I've left out anything specifically. In the prima facie threshold, in paragraph 26 of the judgment, the court made reference that De Beer, who has no legal qualifications, could not articulate the meaning of prima facie proof, and I've subsequently obtained a other court judgment dated back to the 1930s of the appellate division, which sets out the prima facie threshold or interpretation thereof, and that can be found in.
Mr. De Beer, I know the interpretation. I asked you if you knew what it was, and you couldn't answer. That was the point. I do know what it is. So can we proceed to the next aspect, please? You say the court,
Justice Steyn?
the court found there was no prima facie proof. You said there was. I asked you, can you articulate what prima facie is? And I then told you what it was in court, in fact.
Yeah.
So I know what it is. Please proceed.
Justice Steyn, yes, I was then also correct in my interpretation in court then as well. But in any event, let me just proceed with the fact of the prima facie case that needs to be made out. That is all bound and connected to the inquiry that must be held. There was no inquiry. So the court could not have established whether there was a prima facie case, yes or no, without an inquiry. Then in terms of, and then paragraph 27 of the judgment makes reference to MEC for Education, KZN versus Pillay, that was argued by the respondents. In that case, there was also an inquiry held. So all these cases, Manong, George, Pillay, all those preceded, or all those judgments preceded an inquiry that was held. So it could not have been argued because those matters related to matters which were properly inquired by the court. So that could not have been utilized. Specifically in the Pillay matter, paragraph 46, 71, 88, and 97 specifically addresses the inquiry. Then I've dealt with paragraph 30 thereof. Oh, and paragraph 31 of the judgment, it specifically also refers to Hawkson versus Lane. And in that very judgment, the court held that where the equality clause is invoked on the ground that law or conduct differentiates between people or categories of people in a manner that amounts to unequal treatment or unfair discrimination, the inquiry proceeds in stages to assess. So the court has specifically in the judgment itself also referred to an inquiry that had to have happened. And then grounds for jurisdiction of the Equality Court, it is very clear in paragraph 33 of the judgment concern. There's a specific reference by the court itself in the judgment that Dr. Jay is part of an identifiable group. And then I have addressed that. And then further, as far as it's relevant to the decision of the court to ultimately dismiss the case, yes or no, the representation by a non-legal practitioner, and then it was about the suitability of myself to represent the complainants. The court already determined that it did not have jurisdiction. So why it was necessary for the court to proceed to make the finding that I was allegedly an unsuited person in terms of the Equality Act sorry, I can't see the relevance of that. So according to me, the court should have stopped respectfully at the jurisdictional issue and not continued with an ad hominem attack on me as a person. So then I have addressed the issue surrounding the Supreme Court of Appeal judgment against me, which was totally irrelevant. It was a different case. It should never have been even mentioned in the judgment of the Equality Court. And as Justice Steyn is well aware, that is now also a matter before the Constitutional Court to address. And then the conclusions. Paragraph 57 of the judgment specifically says that I find for the reasons enunciated in this detailed judgment that in this matter the complainants have not demonstrated any differentiation by Mediclinic towards them. The procedures under the Equality Act do not find application. So the court could not have made a determination that there was not different treatment of the complainants because there was no inquiry. And then obviously the cost order to finalize, the cost order usually in terms of the regulations of the Equality Act and the regulations specifically say that each party needs to pay their own cost. But based on, above others, the judgment by another judge, Ndita, and also the Supreme Court of Appeal, the court found it suitable to grant costs against the complainants. Where the norm is each party is supposed to pay its own costs. So it appears as if the court used, above others, the cases of Ndita and the Supreme Court of Appeal to basically come to the conclusion that I'm unsuitable, and because I am unsuitable, costs need to be paid by the complainants. Madam Justice Steyn, if there's any other specific question that needs to be answered directed by the court, please may I have that. Otherwise, I am complete with my arguments.
Thank you very much, Ms. Pillay.
Thank you very much, Justice Steyn. I'll be brief. There are three topics that I intend canvassing in oral argument. The first of which is to locate this matter within the proper context in which the in limine points were heard. The second is to deal only briefly with the legal threshold for leave to appeal to be granted. And the third is to deal with the merits of the matter. Justice Steyn, on the first of these, just to locate this matter, we heard a fair amount of argument as to what the real rub of the application for leave to appeal is. And as I understand it now, it appears to be premised on the following. The applicants had a right to have a full inquiry undertaken in this matter. Had they been given the opportunity to have that full inquiry, they could have supplemented and amplified their grounds so as to demonstrate jurisdiction in this. They were deprived of the right to have done so, and the consequence of all of this is that this court erred in having prematurely non-suited the applicants on this matter on the grounds of jurisdiction. Now, we submit that the challenge as brought in those terms doesn't accord with anything in respect of the history of this matter. And it's important that the court actually notes at paragraph 8 of its judgment that it stated in terms what the ambit of this hearing was. And the court then stated at paragraph 10 of its judgment that it was agreed that the issues to be determined at the preliminary hearing were 1, the issue of jurisdiction, and 2, the issue of representation. And the first difficulty that the applicants have in this is that there is no challenge to the correctness of that statement. Justice Steyn, we submit with respect there can be no challenge to it for at least the following reasons. The first is that the matter was approached by parties on both sides on the basis that it was a preliminary hearing in respect of these points in limine. In addition to what the applicant's heads of argument stated at paragraph 2, the conclusion paragraph at paragraph 5 states in terms that they argue that they not only confirmed the jurisdiction of this court to entertain this matter, but they also established prima facie that discrimination took place. And then they go on, and at 5.2 they say, the complainants are of the submission that this matter should, without any further ado, be referred to further hearing, preferably trial. So far from an assertion that says, well, we can't have it heard on an in limine basis, the assertion was we want it determined on an in limine basis so that the merits of the matter may proceed to trial. Justice Steyn, the second difficulty with the challenge as now articulated is that it is manifestly inconsistent with the various letters that preceded the hearing of this matter. And the court will be aware that on the 17th of August, Mr. Bromley wrote to the court's registrar advising that the parties had reached agreement that the in limine points in respective jurisdiction and representation as addressed in the heads of argument would be dealt with separately by this court. Remarkably, that email was followed by a confirmation by Mr. De Beer on the 18th of August, where he confirmed that that is indeed the position. Likewise, Justice Steyn, Mr. Bromley stated in an email dated 25th of August that in order to avoid any misunderstanding, the parties are approaching it on the basis that these issues will be dealt with. Again, no difficulty from the applicant's part in respect of that. And then the court's registrar on the 5th of September addressed an email to Mr. De Beer where she says that the matter was set down in respect of only these two issues. Again, no difficulty with that. So the second point is, in addition to the manner in which the matter was approached in the heads of argument, the exchange, vast and expansive exchange of correspondence that preceded the hearing confirmed that that is indeed the approach. And so we submit there's no basis factually for now impugning the basis on which this matter was heard. Furthermore, Justice Steyn, I must emphasize that there was no suggestion anywhere in the papers that the court, that the applicants cannot properly deal with this matter on the papers, that they want a referral to oral evidence on the issue of jurisdiction so that they may supplement or amplify their case. There was a long break in between Justice Ndita having heard this matter and this court becoming seized with the matter. In that intervening period, there was no leave to put any further evidence before this court on the issue of jurisdiction. There's nothing of the sort. And we submit with respect that this argument is a belated and opportunistic one, the shoe at this late stage of the proceedings. Justice Steyn, just in terms of locating the matter, the further submission I'd want to make is that it's only orders that are appealable. And the order that this court made didn't deal with issues of representation or any of that. It dealt only with the issue of jurisdiction and the issue of costs. The next point is that despite the application for leave to appeal having been sought on a range of grounds, very vague grounds, it appears from the heads of argument that were filed that there's a single point that's being persisted with, and that is only the question of the inquiry. But what was stated in the heads of argument, we've heard now in oral argument that their submissions advanced on the representation point, their submissions advanced on the costs issue. None of those were dealt with in the written heads that were filed. And so we submit that for all of these reasons, on a proper construction of the application before your ladyship this morning, it's really the challenge as articulated in the heads of argument, and this court would then have to determine whether or not the threshold for leave to appeal on that challenge has been met. So, Stan, let me then move on to the second of the issues, and that is the test for leave to appeal. The court's well appraised of what that test is. We've set it out in some detail at page 3 of our heads of argument. I would only want to emphasize the following. Firstly, the applicants rely on reasonable prospects of success before an appeal court, and they rely on other compelling reasons. Precisely what those compelling reasons are remain unarticulated as matters stand. Insofar as the threshold goes, the court is aware that the SCA has said that we have a more onerous requirement for an applicant seeking leave to appeal post the Superior Courts Act. The courts have said it's not about a remote possibility of prospects of success or a mere possibility of it. The question is there a realistic chance on a sound and rational basis that an appeal court would come to a different conclusion? And we submit that that test has not been satisfied at all by the applicants in this. If I could then move on to the third point, and that is the lack of merit in respect of the grounds of appeal as they stand. And there, Justice Steyn, we've dealt with it at page 6 and following of our heads of argument, and we submit with respect that it reduces to 4 grounds on which we demonstrate there's manifestly no prospect of success. The first is that on the facts, this matter was approached on the basis that these 2 points in limine would be dealt with on the papers and on the basis of written heads of argument and oral submissions that would be made. I've addressed the court on that. I won't belabor the point. The second issue is on the question of law, and if I could ask the court to have regard to page 7 of our heads of argument, on that issue. And on that, Justice Steyn, it appears to us that there's some misunderstanding on the part of Mr. De Beer as to how this must be approached. Of course, we do have Section 21 of the Equality Act, and Section 21 does deal with the powers of the Equality Court, and it says that the court must hold an inquiry and then it's empowered to make certain orders. But of course, those provisions dealing with the powers of the Equality Court in Section 21 do not and cannot carry the consequence that even when the court plainly has no jurisdiction, it is not empowered to inquire into its jurisdiction. Clearly, Regulation 6 under the Equality Regulations contemplate that the question of jurisdiction is an issue that the court can competently engage with. And then, Justice Steyn, the only question that remains is the proper point at which the jurisdiction issue may be the subject of inquiry by this court. And Regulation 6 appears to contemplate that it can be done at a very early stage in the proceeding.
Just 1 second, let me just get my Regulation 6.
Sure.
Yes.
And the court will see that in Regulation 6, 5, the presiding officer decides that if the presiding officer decides that the matter is to be heard in the court, the presiding officer must then refer the matter to the clerk, and then there's the process for the assignment of the directions hearing, etc. What we have in this matter is where we had the common cause facts is that we did have a preliminary directions hearing and we had a full-blown argument on the issue of jurisdiction. So actually properly construed, the applicants got more than what the Equality Act itself provides for in determining issues of jurisdiction. They got the opportunity to fully ventilate the issue on the basis of affidavits they had filed, written heads of argument, and oral argument that was presented. And so when one looks at it like that, the high watermark of the argument becomes one of saying, well, the court did have the jurisdiction to engage in issues of jurisdiction, but it ought to have done so earlier rather than later. But there's no consequence to that at all, and I mustn't be misunderstood. I don't concede that that's the correct position, but the point perhaps to just emphasize on that is that the court gave the applicants more than what even the Equality Court contemplates. And the court will be aware that Section 20, subs 3 and 4 of the Equality Act provide for the process whereby the decision is made as to whether a matter is to be heard in the Equality Court. So there can be no dispute, we submit with respect, that this is an issue that the court can competently inquire into. The question of whether it does so by way of a full-blown inquiry or whether it does so by way of argument, the applicant's approach has been that Mr. De Beers represented the applicant. He's got skill and expertise in this area, they say, and he's agreed on behalf of the applicants to approach the matter in this way. In these circumstances, we submit there's no basis on which a court can, on which an appeal court would find that this court improperly or erroneously approached the issue of jurisdiction. The third point that we make on the merits is that Mr. De Beer approaches this matter in line with the case of Berea occupiers. But of course, that's a very different case, and I won't even belabor it, but just the short point of distinction is the Constitution says nobody may be evicted from their home without an order of court made after considering all relevant circumstances. And it's with that in mind that the Constitutional Court says when there's a consent order or when there's an agreement and the court doesn't inquire into all relevant circumstances, it falls foul of Section 26(3) of the Constitution. And it is in that context that the Constitutional Court has said that courts need to take a more interventionist role on that. But that principle is of no application in the context of an equality challenge where there's a representative purporting to have skill and expertise in this area, and where there's an agreement that this is how the matter will be dealt with. And in the course of that engagement, that long and laborious engagement, there's no suggestion at all that the papers as they stand are deficient, are inadequate, need to be supplemented, oral evidence needs to be led on the issue. Absolutely none at all. And for the applicants to come in at this late stage and say, well, had an inquiry been held, they would have been given the opportunity to do all of that, we submit is opportunistic. And then the last issue, Justice Steyn, is the point around the consequences of how this matter was dealt with. And the applicants say that they have had their rights infringed because the court didn't engage in the question of whether the matter ought to be referred to an alternative forum. And that appears to be the high watermark of the alleged prejudice that suffered. But what the applicants are remarkably silent on is the fact that according to the applicants, they have a valid and legitimate claim. According to the applicants, they ought to be able to bring that claim to a Chapter 9 institution in terms of the Constitution, one of which is the Human Rights Commission. There's no suggestion that the Human Rights Commission needs an order from this court referring the matter to it in order to ensure that it's seized with jurisdiction. Of course, we know that Chapter 9 of the Constitution, I think it's Section 184 of the Constitution, read together with the Human Rights Commission Act, allows for members of the public to approach the Commission of their own accord and to lay any complaint that they deem to be appropriate. So we submit there's no prejudice arising from this court's findings on jurisdiction at all. And then the last issue is just under that point in terms of the analogous reasoning is one that I've already foreshadowed, and that is there can be no complaint as to process as to how this matter was approached. The process was a fair, proper, full hearing before this court, where the applicants were allowed to choose their representative, and their representative raised expansive argument on their behalf. And so we submit there's no process issue that's been impugned by the court on this. And the last issue is that I've looked again long and hard in the heads of argument that our learned friends have filed on the issue in the main proceedings. And I see no reference to the need for an inquiry to be held on the question of jurisdiction. It would have been an easy enough submission to be made, and the submission would simply have gone along the following lines. This is an informal forum. Mr. De Beer is not a legal representative. It's occurred to him that there might be issues that fall to be supplemented in the affidavits, and therefore they seek leave for the admission of further affidavits to address the issue of jurisdiction. Alternatively, they seek leave to lead oral evidence on the issue of jurisdiction so that it can be dealt with by this court. There's not the slightest suggestion that that's the course they seek to follow. And notwithstanding all of that, the single basis for the application for leave to appeal, as set out now in the heads of argument, is that of the inquiry. And we submit that that wouldn't get off the starting blocks before any appeal court on it. On the issue of costs, we submit that the judgment justifies fully, and I submit with respect comprehensively, the basis on which the issue of costs was dealt with. And I would submit that there's no basis for a misdirection in the exercise of this court's discretion on the question of costs. And for that reason alone, never mind the fact that courts are generally very cautious about granting leave to appeal only on costs orders, there's no prospect of an appeal court finding otherwise. Justice Steyn, those are my submissions. If you'd bear with me for 2 seconds, just so that I can double check with my attorney that I haven't missed anything. Thank you.
Certainly.
Thank you. Thank you. I'm reminded, Justice Steyn, 2 points. The first is just not to lose in all of this paper the point that Justice Ndita's initial directive was premised on an agreement between the parties. In the chronology of that, there was then some toing and froing on the applicant's part in relation to that agreement, but all of that came to naught when the applicants ultimately agreed and reiterated the agreement that these issues would be dealt with, and that's foreshadowed in the correspondence and email exchanges of August and September of this year. Thank you very much. Those are my submissions.
Thank you very much. Thank you. Yes, Mr. De Beer.
Thank you, Justice Steyn. I'm just going to reply on obviously the new points raised, so I'll be quick. The matter regarding the agreement that was reached, even if it was agreed based on the directions by Justice Ndita that there would be a hearing called for the 2 points, that's obvious, the jurisdictional point and the representation, it does not provide the court with the authority or the necessary jurisdiction to dismiss the case ultimately without an inquiry. And then the matter, the test for leave to appeal, are our case bound on the matter that an appeal court would find otherwise than the Equality Court? Indeed, we do. We reiterate that in the Manong judgment by the Supreme Court of Appeal, it was extensively addressed by the Supreme Court of Appeal itself in paragraphs 21, paragraphs 36, 37, 39, 41, 42, 43, and very importantly, 81. And for this matter, I'm just going to quickly...
Which matter are you referring to, Mr. De Beer?
The Manong.
You know how many Manong judgments there are?
It's the 2009 one. Let me just quickly. In paragraph 81, the court ruled that Mr. Manong, although an engineer, is a layperson as far as the law is concerned. It was for the court below to ensure compliance with and adherence to the provisions of the Equality Act and the related regulations. As stated above, Tonetha Jay stated that Mr. Manong had not applied for a referral to oral evidence. This approach is at odds with the scheme and purpose of the Equality Act. So even if we have not specifically, according to the court and to the respondent, have addressed the issue of that further evidence should be adduced, it was, according to the Supreme Court of Appeal, the obligation of the court itself to have referred the matter to a proper inquiry. So we are just simply saying that at this hearing, if the court was under the impression and would make the decision that there was no jurisdiction, the right thing to have done at that point was to have referred the matter to an inquiry to address the specific points the court believes would not grant it the necessary jurisdiction. That was not made. And then the Irvin Berea matter, it was basically said that, as I've also argued in the beginning, that it's referring to the section 26.3, all relevant circumstances that need to be taken into consideration. In that respect, nowhere in the PI Act is there a reference of an inquiry. This is something that was called by the Constitutional Court. It was something that was brought in by the Constitutional Court, what it deems to have been a proper inquiry in order to obtain all the relevant factors. So why that specific case would not be applicable in this specific matter, we do not agree. It is indeed applicable, and we are humbly asking Justice Steyn to take that into consideration. The alternative forum, yes, it is indeed so that a party can refer matter directly to the Human Rights Commission or to the Consumer Commission, as we are also saying. But the extra leverage and extra power that the Equality Court gives to this is that it's referred by an order to the South African Human Rights Commission. So the Human Rights Commission is compelled by the order to address and investigate it, as we unfortunately know by practice that not all cases before any constitutional or alternative forum are actually addressed by that forum. Many of these cases are falling through the cracks. But the moment when there's an order by the Equality Court to refer it, and for that institution to then report back to the court so that the court can be empowered with sufficient information in order to determine whether it's going to proceed with the Equality Court, hear the matter in the Equality Court, or to just stick with the report of the alternative forum. That is the decision and the power and what has been not given to the complainants, and why they have been prejudiced specifically in relation to that. Justice Steyn, I've dealt with the new specific points that I have not addressed. Sorry, I beg your pardon. The respondent did argue and referred to paragraph 8 of the judgment by the Equality Court, and made extensively that as I can just finally deal with this matter before Justice Ndita. Justice Ndita sadly did not complete her duties according to the complainants and according to me. And unfortunately, because of this, she did proceed with a directions hearing. We cannot say that we will be afforded, or the complainants have been afforded, more than what the Equality Act actually prescribed, because that would be totally not correct, because of the fact that it's only bound. What was before the Equality Court was only the papers filed by the parties, which is similar like particulars of claim in a trial. So it's up to the trial to then make sense of what the papers constitute. And in there, it could have been possible through an inquiry for the complainants, through summoning witnesses and to adducing evidence, that there was indeed discrimination. And we still believe that there was discrimination. There is an indication, a clear indication, that there was discrimination, in that the complainants have been treated differently the moment when they had an opinion about COVID-19 that was not in line with the management of Mediclinic. So from there, it's clear from the papers that, and this is the case of the complainants, that they have been treated differently than those who have just obediently complied with it. So, Madam Justice Steyn, I've said what I believe is supposed to be said regarding the leave application. There's nothing more that I can add that is not in the papers before you. And I'm respectfully would like to then request that unless there's any further questions by the court, that I'm finished with my argument.
Thank you very much to both of you. The court will reserve judgment, and hopefully I'll be able to hand that judgment down as quickly as possible. Thank you very much, and then we will adjourn.
Thank you very much.
Thank you very much.